Okay.
Good morning, everyone. I'm so happy to see all of you. I hope we have some more people coming in. To my knowledge, we will. This is our final session for the family law cohort, our first ever. Today, this is how the program will go. You've all had your breakfast. By the way, I just want you to know that I'm sitting here eating a day-old yogurt that I found in the back of the refrigerator. So, I hope you all enjoyed your breakfast.
Mail you a sandwich.
Let's hope I don't get sick from that, but so I'm so glad you're here, and I have to thank you all for being such the guinea pigs, so to speak, in starting off this cohort. I think it went well. Hopefully, I'll be sending out a survey at the end, and you can all tell me your true and honest feelings. I mean it. If something didn't go well, no matter in whatever capacity, please let us know, because we were kicking off a new one in October, and I want to make those changes as we need to. At the end of the program, we will have a short graduation. Each of you Margaret will announce you, or Thomas, whoever you decide, and hand you your certificate of completion. And I thank you all. I hope it was valuable for you as much as it was for me. And I thank you for that. Thomas and Sarah, thank you. Thank you from the bottom of our hearts. Thomas and Sarah volunteered from the beginning to provide the trainings, and they have been absolutely wonderful. Thomas and Sarah are just a valuable part of the Judicare panel, and we are grateful to you. So thank you so much for all you do for us in this project, and as you represent our wonderful clients. I want to take about 5 minutes, if you will indulge me for a moment. The room seems a little empty today, doesn't it? And I don't mean because we're still waiting for people. I mean, Sally Gold isn't with us anymore. Crystal, she was your mentor, correct?
Yes, a doctor once.
Sally passed away on Sunday.
Oh.
That's what I was hoping you did not mean when you said she's not with us.
Sally passed away this Sunday. I imagine it was sudden. I do not know the details, but I do know that I spoke to her just a couple of weeks ago, and she sounded fine. Let me tell you a little bit about our Sally. All right. Sally's office is located in our building. What floor is she on, Margaret? I don't recall.
I don't know off the top of my head.
I don't recall.
But yeah.
But she was in our building. We saw her often. She represented family law clients across the metropolitan area for over 40 years. She's been around a long time. She handled all aspects of family law matters during this time, and did it with such grace. Such grace. Her goal was always to find the best resolution possible for her client, as if she or he was her only client. She was particularly gifted in her work with marginalized clients, such as the ones we represent here at MVLS. She saw all people as equal and deserving of legal services. She was a member of the Maryland State Bar, the Bar Association of Baltimore City, and the Women's Bar Association, the Women's Law Center, and MVLS. And in fact, she was on our Judicare panel as well. Her motto, or a quote that I really appreciated that she used to say is, practicing family law, I'm going to read this, gives me a chance to model good problem solving with the hope and expectation that my clients will learn to do the same. In other words, she empowered her clients to get better, to do better, to be stronger in their lives, and as they move forward during and post family law issue. She was on the board of MVLS. She was a former board member. Obviously, she was a mentor for our family cohort. She was a friend and colleague to all of us and will be missed throughout our legal community. I knew her as fearless and determined. I knew her as kind and caring. She was a loving and family member, and especially she regaled in talking about her grandchildren, of which we both had in common. One thing, if you haven't met Sally, but once you do, you would always remember this. She was stylish. She was always dressed to the nines. And we loved that about it. You could see Sally down the hall and know it was Sally with her back turned to you. You knew it was Sally. So I'd like you all to just, as you go through your day and as you practice family law, remember Sally and the things you do in trying to emulate her in some way. I will miss her. I know we all will. And the legal community is less without her. So thank you for giving me this time. Let's dedicate this meeting to Sally Gold. Thank you all. Thomas, do you want to take over now?
After that, no.
I know.
Oh, man.
I know.
Introductions.
Yeah, I think we do want to.
Oh, yeah, that's right. Let's go around the room and just
launches in.
introduce ourselves.
And I'll just say really quick on logistics, if anyone needs to use the restroom, there's a key at the front desk. Amani can give that to you and show you where it is, and feel free to come up and get coffee and tea and what have you.
You all know who I am, Nancy Grimm, Family Law Director, MVLS.
I don't mind going next.
Okay.
Thomas Mulinazzi and MLO Mulinazzi Law Office, where Sarah works with me. And I did know Sally, not too much personally, but professionally. She taught me some things, and very sad to hear. So, yeah.
Sarah Nadolny, I work for Thomas, as he already told you.
I am Curtis Cooper. My office is one block west of here on Liberty Street. I'm a solo practitioner, and I actually got into doing family law less than 10 years ago through MVLS. So I don't have a mentee this year, but I've met many wonderful mentees already. And yeah, anyway, it's a great program, and hope you all continue on.
Good morning, everyone. My name is Kendrick McLeod. I'm an assistant solicitor at the City Solicitor's Office. This is my first experience with MVLS and family law in any real professional sense. So thank you for having me, and it was great to be part of the cohort this year.
My name is Jessica Keister. I am also a mentee. I'm at a family law firm in Howard County, and yeah, this has been great.
I'm sorry, I went to the wrong place.
Oh, no worries. We're glad you're here. Come on in. We're just doing introductions. Feel free to sit anywhere. Any open seat is yours. Get you.
John Hudson. I'm a solo like Curtis is. I actually started my career at MVLS back when I was a 1L at the University of Baltimore. This was the first position I had, was as a legal intern at MVLS. So
I
it's
didn't know that.
nice to come full circle.
That's awesome.
Hudson, what's your last name?
Miller. Actually, Jessica's my mentor. So it's a nice little family unit we have going here.
Yeah, some good people in your camp.
I'm Crystal Collins. I do mostly do family law and guardianships because I have a special needs child, so that's why I have that interest as well. I graduated law school in like 2000, I worked for a few years and then I took time off because of a special needs kid and decided to come back about 2 years ago and start a practice again. So just want to get back up to speed because when I was practicing before, there was no MDEC and a lot of things have changed. So I just wanted to become a mentee because although I did have some family law experience, I just wanted to get more up to date on things. And my office is in Tallahassee.
We're glad to have you.
Sally Gold was my mentor. I'm glad I got a chance to speak with her before she left.
Do you want to introduce yourself?
I'm sorry.
Doris, do you want to introduce yourself?
Oh, I'm
Sorry.
sorry.
Put you on the spot.
Person went to,
All you have to say is your name, where you work. if you
Doris
want.
Walker. And do I need to say anything about myself?
Only if you want to.
Yeah.
Yeah, it's up to you. Most people just said,
Doris.
yeah. All right, well, I think we'll turn it, oh, and Jessica
Yeah.
Jura, do you want to, you want to introduce yourself?
I am here. I'm sorry. I have contractors at my house today. I apologize. I'm Jessica Zadura. I am a family law attorney in Anne Arundel County. Hudson, as he mentioned, is my mentee. I have been serving as a mentor, and I have known many of the other mentors for my entire career at this point, and I've been volunteering at MVLS the large majority of my career as well. So thank you all for having me.
Yeah, Jessica. I don't think I introduced myself. I will as well. I'm Margaret Henn. I'm the Deputy Director at MVLS and just want to thank you all so much for being a part of this. We're really excited to have this be our first completion of our first family law cohort, and you were all a part of it. So thank you.
My turn.
It's your turn
Well,
now.
first of all, Jessica, I'm glad you're here, and hopefully the contractor thing goes well. We were tasked with doing a presentation, not about how to be a BIA, which is a totally different issue, and other people have done that, and we couldn't possibly do that in a couple hours, but tips and how to work with BIAs. That's a very broad topic, but we thought we'd break it down in some slides and discussion. And Jessica, I'm hoping to lean on you. So if the contractor needs you, I'll just figure that out when you don't respond, because it's kind of, some of this is from our perspective, Sarah and I, but we did reach out to some people and got some feedback. So we start with, I suppose, the second slide, which is, do you even need an attorney for the children? So we're talking about custody and access cases. I don't think you would for a child support case. I've never heard of it, of an attorney being appointed in a child support case where there's not custody also. So putting that to the side, you have to ask yourself, why would you need that? How does it help your client? And as you know, as family law practitioners, we have a unspoken duty to protect the best interests of the children also. But does it help your client? Because it might not, which is an interesting position to be in, which probably means you might have the wrong client, but it is what it is, and that's how life goes. So we just wrote down a couple of reasons why an attorney for the child might help. And if anyone has any questions about that or about it, what any of that means, or if there's anything else you see, but of course, depending on what type of attorney, their job would be to protect the child. But when it comes to a best interest attorney, usually they have the ability to waive privilege. Not always. We'll talk about that if you want. So they would be able to speak with providers who would otherwise have confidential information. And you may or may not get that information, but they have the ability to get information that you don't. The very, very bottom, you might think, what's that about? Thomas and Sarah are saying, hey, the court might be able to get hearsay from an attorney. Let's talk about that more when we get into a best interest attorney, but generally speaking, the court's going to want to hear from the best interest attorney what their opinion is of what's going on via their recommendation, which Some, a lot, most comes from the child, which you may or may not consider that hearsay-ish. So that's what I mean by that. And furthermore, we'll talk a little more, when the BIA is working with you throughout the case, as the BIA talks to the attorneys, inevitably you're going to hear, the child feels this way, or some of the people I've talked to feel this way, which is purposely vague, but is classic hearsay. So please don't take that to mean that we think that.
And can I just throw a little wrinkle into the whole everything, because
Okay.
I have represented parents in the center arena for a long time. I actually started representing children, but I've represented parents a lot. And so I have wrangled with children's attorneys on many occasions, and not just the center context, but in custody cases. It depends, not as much, but sometimes. So I'll just periodically
Please, that's,
go in
yeah,
something from a different perspective.
no, that's what we're hoping for.
Yeah.
And one of our colleagues, Karen Amos, she's a very veteran practitioner in Howard County, done a lot of Baltimore County, also signing on. We recently, what? No?
No, I was gonna say, and new, but you started to.
Oh,
I'm
right.
gonna say, I'll
And we're
make sure she can talk.
Very
There we
proud that
go.
we recently
Yeah.
harassed her into joining the panel.
Excellent.
So
Good morning. Can you hear me?
Yes, we
yeah, we
can.
can hear you. Nancy, you're going to see that that was a high quality recruit on our part. You'll see that you owe us big time.
You're muted, Nancy.
Said it was, amen.
So the next slide, point of order, is, what are your options? And depending on what's going on, they might be good, they might be bad. And I thought I'd throw in the option nothing, which is what I often tell my clients, because they might do that anyway. So you could just not have any attorney for the child, and that we'll see how that goes. So there's differences, of course, and we're gonna go through that. So this is just kind of a roadmap type slide, which, why don't we just go to the next one then? Start with custody evaluations. The custody evaluations, we also have a handout. Now it's from, and we have enough for people here for sure. 1, 2, 3. I don't think Margaret wants one, but you're welcome to have one.
Nancy sent me on the handout, so
Okay.
I got the
So I
other.
don't know if you want to have it in your hand, but I think that's for, you can take one, pass it down. So, I think you want one, Chair. This is from the Howard County Circuit Court, where the main social worker there passes this out. So it's not necessarily the same in every county. It'd be close. It gives you, as the attorney, and it all, this is directed to the litigants, what's going to happen in a custody evaluation, which there's a lot going on. I wrote, it's always available, but maybe not. For example, in Howard County, as of 2 years ago, we had one custody evaluator, and they were very prudent about when they agreed to do an evaluation. Now, I don't know what happened, but we're up to 3, and now it's a whole different ballgame. So they're pretty liberal about granting that, and different counties have different policies. Forever ago, and I can lean on Jessica Keister on this more because her experience is more recent, but in Baltimore City, there was the custody and adoption unit, and I don't know how they, a long time ago, they seemed to be pretty open about doing that, but their timelines and resources and difficult to actually get a lot of information to get it done quickly and thoroughly. But I don't know if you can you give us a little bit of info on that? What does that look like in the city? Because that's where a lot of these cases are.
Yeah, I think it's definitely fair to say that it pushed, like when we were picking dates with the assignment office, it pushed dates like months and months and months farther back to give the evaluator time to do the evaluation. And then I also kind of felt like they weren't done. Like sometimes they didn't really give us any helpful or useful information, but.
And I would assume that sometimes they weren't that thorough because it's so difficult to be thorough in the first place. And when we're doing these cases, we're like, well, if you would have talked to the coach, or if you would have talked to the next door neighbor who's only in town one weekend a month, you would know. But that would change everything.
Can I just share a couple of thoughts on custody evaluations? The good and bad of custody evaluations is you never know how they're going to turn out. And so if you ask for an evaluation and it goes against your client, then you're
stuck
on an uphill battle to try to try to get the court to not accept the recommendation. But those custody evaluations, you need to scrutinize them very carefully for the basis that the evaluation, the basis that the recommendation is made, the factual basis, because there are times, and I found this a number of times, that the underlying facts are incorrect. And so to the extent that the evaluator has based the recommendation on these facts, then if of course, if they're in your favor, your client's favor, you're not going to want to go after them. But if they're not, to the extent that they have relied upon information that is incorrect, then that can reduce the value of the recommendation. And we should continue to argue that too.
No, that's a good point. It's like with testimony in general, but it's more important when it's an expert.
Yeah.
So this slide is trying to show you compare and contrasting, but it looked better if I chose that little spinny wheel thing. But so right now we're talking about court evaluations, and everything Doris said certainly applies to court evaluations. And Jessica was talking about the court's schedule and timeline, which can be difficult depending on which jurisdiction you're dealing with, but always with court custody evaluations, it's going to take a little bit longer. I mean, it's free, and therefore the resources are limited. So it also might not be available in the jurisdiction. If it's not one of the 5 unified counties, which Howard County is not, but I know some of the smaller jurisdictions in the West and the East, they don't have that. So there might be an alternative service, maybe it's a regional evaluator, but you can imagine one social worker for 3 rural counties. Good luck getting that. Hopefully no one gets mad at me. I wrote less experience generally, meaning these are social workers that don't have as many years under the belt. Now, sometimes someone stays around for a while, but I'm just writing that down to contrast that. And this goes a little bit to Doris's point. Just like we get better as we do this more, same thing with social workers and custody evaluations. And it's very much an art also, because these are LCSWs or MSWs, not psychologists. So their observations and their interpretation, contrasting or comparing with, by the way, have you all seen the show Shrinking? That's a little up in the top corner. Harrison Ford is a fantastic show about psychotherapists. It's really funny. So the private custody evaluation, you can always get that.
Thomas, can I just mention something about the court evaluations?
Sure, please. That's
Okay.
Karen Amos.
I just thought I'd jump in and kind of give my 2 cents. Can you see me?
And
Ken, if you want.
we're gonna put you, well, no.
I mean, it doesn't matter. I can't really see you,
I think
but
you're-
I'm sitting in the
you're
courthouse anyway.
We
so-
see a picture of you.
Okay, that's probably better than how I look sitting in the cafeteria. My thoughts though on court evaluations is that I generally hesitate to ask for them unless it's something, 1, because of the delay in a case, 2, unless it's something that's really going to jump out and that the court evaluator will be able to see. then I don't want to ask for it. And that's, somebody could be a hoarder. That may be where you want a court evaluation. My concern with asking for them, if it's anything deeper, maybe it's drug addiction or mental health illness, is that you're probably not going to get much insight from the court evaluation. But then what you may have, because remember, if they're appointed, they're sort of an arm of the court, is what I consider sort of a rubber stamp. Okay, mom's good, dad's good. And then that might be an uphill battle for me, right? Because they haven't gotten into the details. So that's just sort of my thoughts on the court evaluation. Sometimes they can be good, but I think they're very surface.
Okay, no, thank you for that. And you touch on a good point that they are an arm of the court. Literally, they work for the court. And then you get into biases of the court. And to Doris's point, if the conclusions are not based on solid facts or based on incorrect facts, then we have to do our job as litigators and I don't want to say attack, but discredit that conclusion, knowing that we're dealing with an employee of the court who they spend all day long in the back halls with the magistrates and the judges and everyone else. So that's has to be done, perhaps more delicately. In essence, you're saying your employee did an awful job, and let me explain why on the record, and you do with that what you will. But that's a very good point. The private custody evaluation is very expensive, and depending on how many children. But you're looking at now whether or not the custody evaluation comes along with psychological testing. If it does, you're definitely north of 20,000 into 30,000, et cetera. And it can be quicker, especially if the professional is available, which sometimes they're not. There's not that many of them that do it. And because it's a very hard job. If it goes to trial, then there's probably an opposing counsel who's probably very good at his or their job and are coming at the evaluator pretty hard. There might even be another private custody evaluator, but rarely. You can ask to have a joint expert, but even then, as Doris is pointing out, if it doesn't go your client's way, and you have a client who can, and this is not MVLS cases, but who can afford half or some or all of the $20,000, $30,000, $40,000, they're very likely to want you to debunk what's going on, and then you're in for it. But it's very interesting. And one point I have to make is, even though you have these experts, whether it's the court evaluator or the private evaluator who has 8 PhDs and has published 1 million books, it's still the judge's decision on what he or she thinks is appropriate for the child. And one would think the judge would give a lot of credence to the opinion. Depends how good a job Doris did in ripping up the opinion and the basis for the opinion. That's true. But some judges are very strong on, this is my decision, and that's just one piece of information. And we have a case still going on, it will always go on in Howard County, that the first time, maybe it was the second or third time it went around, a very prominent custody evaluator was paid with testimony, probably $40,000. In fact, I know it was. And the judge said, well, I think he's biased. I'm very uncomfortable with the way he keeps referring to the mother in her first name, and I can't give a lot of credence. And notwithstanding, we've already had 10, 12, 15 days of trial, I'm going to order a second custody evaluation. And then he ordered Dr. Berman up in Towson to do it, which was another $40,000, who came to the same exact conclusion after the big, ginormous report. It's actually a little bit more favorable to mom, which was interesting. So there you go. Fantastic. And it didn't really help because we keep on fighting, but on
and I was involved in that case, and it created I represented dad And it created a huge delay when we stop in the middle of trial. And the court says, look, I'm just, I'm not buying anything that this evaluator is saying. So, we come back, 6-9 months later.
Right.
And I think that leads to one of the points that if you're going to ask for a private custody evaluation, that you have to do it very, very early on, with the case time standards being a year. Some of these custody evaluations, you're 4, 5, 6 months out from them being able to see you, or that's been my experience.
Yeah, I do. Well, there's lots of pros and cons. With the private custody evaluation, usually you get a sit down and some feedback, and she may do a little bit more work, frankly, to cover their own butt, but to do a much better job. But that comes with a cost. And but even we pointed out one situation where that didn't work. So now people usually ask, I don't want to assume the questions, when a custody evaluation versus an attorney for the children, people have different opinions on that. Generally, if the children are younger, because it's more difficult for the BIA to build rapport, if there are some significant mental health issues or some significant substance abuse issues where you need a professional to do some investigation and psychometric testing. Love that word. And there are many, many other reasons why you would go the custody evaluation route rather than an attorney. But the biggest difference to me is you're not getting any real-time interaction. It's the evaluator's doing his or her thing over months, putting together a report, and here you go, here's my opinion. So they're not jumping in and trying to solve any problems. But we'll talk about that more in the next slide, and then answer any questions. So let's move on to the different types of attorneys. We used to call it the Nagel Hooks attorney. If the child, so pardon me, I'll use child and children interchangeably, has a therapist or other person in his or her life that they're confidential communications, if you feel it's important to have that information come in, it cannot, because it's confidential. It cannot unless there's an attorney appointed to evaluate the situation to see whether or not it's in the child's best interest, or if the interests of the court are so significant that outweigh a mild infringement on the child's interest, to have that information come in. Generally, the answer is no. Generally, if you do nothing, then the information doesn't come in. So it's the same as an assertion of the privilege, just doing nothing, which sometimes attorneys who don't practice family law don't understand. Well, there's no child privilege attorney, so I can depose the therapist. No, you cannot. That's not how it works. So this is basically a limited scope BIA. That's just an analogy. It's not really the thing. And the child's privilege attorney will speak to the therapist. When I do it, I ask both parents through their attorneys, what's your position on this? How do you think the therapy's going? What's your feelings about the quality of the therapist? Do you think it's helping, et cetera? And just leave it at that. I don't need a lot of information from them. And then I talk to the therapist, and that might be enough. Sometimes the analysis is there some information that only the therapist has that is determinative, and the other attorneys can't get it another way? Then I pursue that a little bit more and talk to the attorneys and see, just to try to get a better idea. You would assume that the privilege would be asserted all the time. That's not necessarily the case, but it's certainly more often than not, and different attorneys have different feelings on that. If the treatment's ongoing, you would think it would not be waived. But if they haven't seen this therapist in a year or even 6 months, and there's zero chance of that happening, then maybe you waive it. However, unless it makes the child feel like, I don't want to ever go to a therapist because my therapist got hauled into court and all the beans got spilled and this is awful. I can't trust any adult. Sure, that makes sense. I had a very unique situation in Baltimore County where when I talked to the therapist, he said, come into the therapy because you're going to see that. And Karen, you were somehow, I forget how, involved in this one, but it was very interesting. The child would call both of his parents from the therapy, and there was just zero confidentiality there. But the kid was, I don't know, 10-ish, and it was very healthy, but there was no confidentiality. And therapist asked the kid in front of me right in the room, because I think it's the only time I've ever gone into a therapy session as a privilege attorney. It's like, yeah, sure, happy to testify. I talk to them all the time because I don't know if that's a good idea, but what's done is done. So yeah. So and then how it is waived or asserted is just a 1-page. I don't even.
Next slide.
Is it? Yeah, because it's next slide. So I took this from Rhea Rockvarg. She just, wrote the therapist's name, waiver on the side, yes or no. And then I included it in the title because when I used to work in Baltimore, Circuit Court for Baltimore City, I work with the clerks a lot, and they're like, we'd rather just know what's going on in the title, because we're not reading this. So, and then I always put a reason or two in the bottom, which is pretty standard. You just want the court to know you thought about it a little bit. So I don't know if there are questions about child's privilege attorney, but I'll say that usually it's built into being a BIA, but you have to check. Sometimes it's not.
Curtis had a
Yes, sir.
comment or question.
So like for other medical records, just, regular doctor's appointments or things like that, does the child's privilege attorney come up? I guess, it's nice to show the kid's going to the doctor or whatever, or not. If the kid's not, that's one thing. And that doesn't seem like a privilege question, but maybe there's something that comes out at the doctor's appointments that might be.
Right. I can see why you would think that. And I could tell you a lot of Karen and Jessica's, Jessica's or Jessica Heiser's experience. Jurists get pretty upset if you try to introduce children's medical records where there's no BIA because what's HIPAA violations, it seems like an infringement on their privacy in general, and inevitably there's going to be something in there that's a privileged communication. So that's a tough one. I had Judge Bryant at Baltimore City really ream us out for that, and for even trying, but she'd like to do that, but that's fine. And so I would say, in my opinion, that when you're talking about guidance counselors, doctors, then it probably should be, it probably will be excluded. Jessica, did you have Magistrate Tate let any of that in?
I think she did.
Did she? Okay. I don't know if Karen or Jessica, what your experience has been with that type of information.
I have not had that medical information excluded. Each parent has a legal right, statutory right to house medical information.
Which
So
is different than publishing it in a court record.
Well, it's going to be, it's not going to be public information anyway. It's going to be like, essentially tantamount to under seal. So it's not going to be available to the general public. But to the extent that medical records, because a lot of times you're going to get into this parent take the child to the doctor when they needed to and so forth. And like I said, a lot of the parent is going to be able to access the medical information, and if you do it the correct way in terms of usually have the custodian have it submit with the custodian records, I generally have not had a problem getting doctor information in now, anything that touches on any type of psychological issue or any type of therapy or anything like that. Yeah, absolutely. You're gonna need a privileged attorney.
Yeah.
But medical records, I have not generally had a problem with.
And sometimes you can get it redacted. Hopefully that's done in advance, but
Well, and I think following up on that, while I think that, you can have the certification and have medical records entered, as attorneys, we need to be very careful with that. Whether they're sealed or not, it's somewhere out there.
mhm,
And there's going to be very few occasions when you actually need to put medical records of a child into evidence. Whether a parent attended or not attended, that's really, you don't need the medical records for that. I had a case before Judge Kramer one time, and the opposing counsel was trying to get in records where the little girl had, I mean, it was basically a gynecological exam, and she stopped and said, wait a minute, this child could get this transcript. What are we doing? And so we have to sort of pause, right, and say, is this something that's really necessary anyway? Whether I can get it in or not, should I, right?
right? That's a great point. That's definitely something that we should keep asking ourselves throughout this when we're doing custody and even divorce, but certainly when it has to do with children. And sometimes when we're thinking about the rules and the evidentiary rules, we forget that. That's a great point. So the other type of, go to slide 7, is another attorney before we get to the BIA, is a child advocate attorney. And this is interesting because it really comes down to considered judgment. But when you represent a child as a child advocate attorney, you're doing exactly that. You're advocating for the child, for what the child wants, even though they're not an adult. And I'm going to pass around a petition from the child to enter the case under 9103 when you're 16 or older and you're quote, subject to a court order on custody. You can ask the court to change it yourself as a 16 or 17-year-old. So if you're the child's advocate attorney, and Karen can speak a little bit on this because she's actually reached out to her and asked her to do it once or twice. You represent that child as you would an adult with differences in style. But one point on that, if the child doesn't have to be 16, but if they're not, you can't just, the 15 or 12 or whatever child can't just hire an attorney and show up. Forever ago, Judge Carrion, appointed in Circuit Court for Baltimore City, appointed me to be a child advocate attorney for a 10-year-old. That's because Her Honor decided that 10-year-old had considered judgment. And if you know Judge Carrion, that's the end of that. That's what she decided. So, and the child, was kind of mature, but she had a tough life. So in many ways, but when you're the child advocate attorney, you employ a lot of the same strategies, skills, et cetera, as you do when you're the best interest attorney. But Karen, since you're on, and I know you've done a couple of these, do you want to talk, let folks know what it's like to work with the child advocate attorney, and just briefly a little bit about that? Because this session is more about how to work with a child advocate attorney. But I will say how to get one is if the child's 16, somebody has to come up with the money. And then Karen, you can maybe explain how that happens.
Sure.
Retainer, et cetera.
Sure. So generally, if the child is 16 years old and we're going to file under this statute for a change in custody, you're usually going to have one parent or the other that's going to be bringing the child into you. And one parent's going to be paying. So you have to be very, very careful because you are not representing either parent. You are only representing this child. I make it clear from the start that the child is my client and I'm going to follow their wishes. And so, everything that we discuss is confidential. The child has to file the motion to modify custody. And, most of these cases are not going to be litigated. The hope is that if I'm filing on behalf of a 16-year-old who has considered judgment and who is probably, spends more time socializing and at school and, is doing what a 16-year-old should be doing, then the parents will understand that, look, this, we have forever with this child, right? And so we don't want to interfere and have a contested custody case over a year of access or whatever. And, candidly speaking, if a 16 or 17-year-old doesn't want to go with the other parent, a court's really not going to do much of anything. So I think one of my roles is to sort of encourage both parents to see past what the child is trying to do sort of at this point, give the child space, let them grow up. But we're not looking to, cut ties with the parent. So it's, it's really sort of a delicate balance to get it done so that both, understand where the child is and that it's not necessarily a rejection of a parent.
A great point. If you could go to the next slide. When you're a child advocate attorney, the presumption is that the child has considered judgment. I have had cases where I have been appointed as the BIA for children over 16, and they've not had considered judgment. The one case I can think of, it was a result of disability. So she had an intellectual disability. So that was, no one really fought me on that one. But considered judgment is kind of a fluid, but defining considered judgment is not exactly easy to pin down. But we pulled the information out of from the see the site there. So I always say, well, do they have an opinion? Of course they do, especially when you're dealing with a teenager or preteen. But does the opinion make sense? Do they know the consequences of the opinion? Do they have good reasons for the opinion? That's probably the shorthand on how to do it. I'm sorry, how to define it. But there's a lot to it. So, and of course, is there anything else? Like, is there emotional disability? Is there intellectual disability? Is there pressure, unfair pressure? But
Substance abuse, maybe.
yes, right. Yeah, it's a great point. Before we go to the next slide, we're talking about options. And one option is to do nothing if you have a child in the middle of this. But the one, I think an awful idea is to have the child testify. So the way it works, and I look for input on this, Jessica or Doris or Karen, there are two options. Well, one option is the judge says no, which is very likely. Or the judge says, well, how about in camera, which you can object to, good luck, and then it has to be on the record. Then the judge or magistrate clears the courtroom, puts it on the record, no one's there. But generally speaking, that's an awful idea because you're subjecting the child to putting them right in the middle of this in a courtroom, which will probably be very traumatizing. And to testify against, even indirectly, against one of the people they love the most in the world, even if they don't think if they're not actually doing it or trying not to, they are in fact. But, and then whether or not you can submit questions for the judge, every judge does it differently if they even do it.
I will throw in my, I won't call it a horror story, but I would call it, I think, a learning experience. And this was when I was representing children in Senate cases. And And there was, and my client, it was a emergency hearing. And the question was, you know, his mother had physically struck him, and he didn't want to go back home. But the only way that really what happened was going to be proven was by his testimony. So he testified, and he was not returned home on an emergency basis, and he was declared sinner. Ultimately, ended up in the system. I don't think they ever reconciled. And the mother, and I did not know this, of course, about her at the time. She herself had actually come up through the system, and she had through the foster care system, and you know, and she was, you know, I think trying to be a parent to this child. But the thing I learned about that in that experience was that I think that really damaged the relationship between the two of them so much that I don't know that it ever really recovered, because it snowballed into, like, say, you know, him remaining out of the home, and she ended up getting prosecuted criminally. She was found not guilty, but she ended up being prosecuted criminally. But like I said, the whole thing, I looked at, you know, what was it good to sever that relationship? Because I think that's what it did, or it damaged it to the point that it was that it never recovered. And so that is something that I learned, that you really have to be careful in making these decisions, because they can have consequences, long-term consequences that, you know, can damage the family and the child.
Sure, thank you. That kind of goes to what Karen was saying. That's a great point, but
Yeah, and this is sort of out of the box a little bit, but I had a case years ago where someone brought in the daughter to testify just about how much dad had done and paid for private school and blah, blah. And she was in her 30s, and Judge Harrington said, "What are you doing? I don't care how old a child is. You're going to put this child on the stand," and it really was. And the child ended up testifying, but it was clear. I mean, I wouldn't have done it, right? It just, no matter what age, you don't really want a child in the middle of their parent's case if you can avoid it.
Even when we had corroborating witnesses for divorce, I don't know how many years ago that is now.
Yes.
They didn't want that either. And I had to do it once, but I said, here are the questions. We all agree that both these people are wonderful human beings, and that's what you're going to say, right? She said, yep, I'm just going to say they haven't been together in a year. I'm like, is that all right? And I forget which magistrate it was, but yeah, you're certainly right. Those of us who've clerked may have seen, I'm guessing Jessica Keister has, interviews, in-camera interviews. And my opinion, it really depends on the judge's skill set. And some judges, sometimes they're new, sometimes they're just got a bit of robitis and think they can do this, and they can't. And some others have a lot of training and a lot of experience in this area, and they're fantastic. They're like social workers, and it's really gentle, but it's still at court. They're still in chambers. Judges usually take the robes off and sit down, and talk about whatever they're interested in, which doesn't seem particularly robust in gathering evidence, but that's what's most important is the child. So I've witnessed that as a law clerk. I've also witnessed that as a child advocate attorney, and once as a BIA. So because as a child advocate attorney, if it's going to go to trial, and the only reason it did is because the other side had mental problems, they're a party. So yeah.
I just wanted to, yeah. I actually haven't done, an interview in chambers, but I've like moved. And the first time only a couple times, but the first time I did was in an MVLS case, kind of came into it. There was a modification hearing in a month. So I said, I'm going to move because, the child had been with the mom. The dad was trying to have more custody and whatnot. And like the judge didn't want to hear from the kid, but I think just filing the motion, and there's a the appellate court now decision that talks about it. So there's some precedent, and I found it was helpful. The judge didn't want to hear from the kid, but I think the judge got the message.
I will ask for an in-chambers interview. I don't put children on the stand, but some judges will say, hey, if the child's going to say anything, it's going to be, they may, like say, they may take off the robe, may do things to make the child comfortable, but they're going to say, hey, it's going to have to be here on the record. Now, if I ask for an in-chambers interview, I will also ask that it be on the record. And sometimes you will submit your own questions that you want to ask the judge to ask, which they may or may not ask. But sometimes they're not all that helpful because judges don't want to, they didn't, of course, not going to ask who do you want to live with kind of thing. And so, what information do they glean from these indirect questions?
And they're also
varies.
They're also asking if the child's going to testify in chambers, on the record, whatever, it's still a child. So you have an immature witness. So the witness, by definition, has a disability, age being a disability. So they're going to say perhaps immature things. And the only time I've ever lost a case as a BIA, the judge decided to interview my 13-year-old client, who is a boy, which I could say this because I'm a boy. We are not as smart or as mature as you are at 13 when you're 13. So it's not, and he wasn't. And I said he doesn't have considered judgment because I had to. And I explained why, because I had to. And she still wanted to interview him. And she just became, I watched it. I saw her become enamored by his by his excitement about moving to the Pacific Northwest, because he was, in his mind, he was going to play varsity soccer at this really amazing high school, and he was going to eventually play for the Portland Timbers professional soccer. To which I said, I got to tell you, my kid played soccer with this kid. He's not making it. Yeah. So anyway, you get the children. So what they're going to say might be childish, but that brings us to the one that usually people want to know about is BIA and how to work with BIAs. Again, we're not talking about how to be a BIA, but we might a little bit. So the next slide is what is a BIA? Beep. That's all right. So it's not a guardian ad litem. That's just a stock photo I could find. That's what it used to be. When it doesn't really matter anymore.
States call it that.
What's that?
Other states call it
They do,
guardian.
don't they? Right. But that's when the attorney doing that had protection of the court and couldn't be sued, was an officer, well, you're always an officer in the court, was appointed by the court and protected by the court. Now we're out there. We need to have good malpractice. But that's the stock photo, and I didn't want to figure out how to erase that. So
I like the shield.
you don't have an allegiance to either parent. And when I send out intro letters, I make sure when I send out intro letters, it's to the important third parties in the mix. So teachers, principals, coaches, therapists for sure, maybe doctors, especially if I'm told that there are confidential communications going on with the primary care physician or the specialist, because sometimes doctors do a good job and actually ask you what's going on with your life, and then they'll put it in the notes. So I emphasize, I'm not working for dad. I'm not working for mom. We don't have any duty of confidentiality to the child. However, your main job is to protect the child and get them out of the middle of the conflict. If there wasn't a serious conflict, there wouldn't be a BIA. And the more you do it, the worse your appointments are. I don't know if Karen feels the same way, but when I do get one, I'm like, what the hell is this? And they're like,
Becomes more and more challenging, right?
right. And they're like, well, we did, we knew you'd be able to handle it. I'm like,
The first one off the bat that I got was 9 children that spoke Korean.
9 children.
How was it gonna get worse than that?
Well,
That's called punishment, Sarah.
Yeah, okay.
that was supposed to be like, Sarah can do it and you can help. I'm like, how many other attorneys? But but yeah, if you're not, only the tough cases need the BIAs. So you can see what your job is, to advocate for the child's best interest, once you can figure that out, which requires a lot of work. Because you got mom saying one thing, dad saying another, same-sex couple, whatever, parent A, parent B saying, otherwise they wouldn't be in this problem. Attorney 1 saying X and attorney 2 saying Y, and sending you information that goes to that point. So let's go to the next slide. Oh,
Wait, go backwards. Go back. You want to talk about, yeah, you can go back, but I wanted Thomas to go back. If you have different rules for different kids, conflicts in here.
okay. When you have multiple children that you're representing, like if there are 9 of them, for example, you're probably going to there might be different preferences for where they want to live or how often they want to see parent 1, parent 2. I had a case where I had 4 kids. The oldest was 17, then came 16, then 14, then 8, girl, boy, boy, girl. And the 17-year-old I alluded to before had developmental disabilities. So she did not have considered judgment. And then the 16-year-old boy did. The 13-year-old boy, maybe. And the 10-year-old girl, or 8, whatever she was, definitely not. But, the mom got along better with the girls, but you have to be careful when you have multiple clients, because there might be different scenarios that work best for them. And not really in this case for reasons because of what mom was dealing with and how she was reacting and how she was problem solving her problems, which she wasn't. So that was easier. And sometimes even though with the 16-year-old boy, I could have asked the court to reassign me to be a child advocate attorney or bring someone else in for that boy, and I represent the other 3. Based on what he wanted and what the best interests were, they aligned. So it wasn't a problem. And I told the attorneys that this is how I see it. And if they're not aligned, then I need to recuse myself. I need to withdraw from the representation of the 16-year-old. But that never happened. There are other cases where that may have happened, that may happen. And in some cases, and I have one now where I'm not the BIA, but the BIA has decided the 2 children need to be split up. Now, one of them lives primarily in Hagerstown and the other one lives in, I guess, Western Howard County for their own safety, because one of them tries to hurt the other. But that can happen. And I tell you this because when you're working with BIAs, that's their call. And so now there also can be conflicts within the children, which I just explained, or BIA conflicts that you may have, like the kid who played soccer with my son. I told everyone up front, I said, this was 2 years ago. I talked to both parents now and then. We didn't sit next to each other. We didn't, share the sippy bottle full of, daddy juice. It's just, we weren't like sipping the vodka. It's just no big deal. But, and both parents like, yeah, I remember Thomas. Yeah, it's fine. It's no big deal. But we trust him to whatever. So it looks like that's it. Yeah, I'm just saying you might have to advocate different positions for each child, but if they're dramatically different, then you might need to bring someone else in. Yes, ma'am.
So when do you know when you should ask for one? Because I had a case where the dad had the kid, but he was going to pick up the kid in the middle of the school. The mom really was on the fence about getting full custody. She just didn't want to pay child support. But I felt like the dad was picking up the kid from the school. The kid was wilding out, causing food fights, flirting around with other kids, making other kids feel uncomfortable, making sexual advances on other
Really?
kids.
You had me in food fights.
Yeah,
All right.
I mean, she was just wilding out. The kid was wilding out. You know what I mean? And
Yeah.
so
I'm looking at the slides ahead and I think that I'm gonna cover that, but you will not let me get off without answering that question, right?
okay.
All right, good.
Thomas, is there any point during this that you want to take a break during the slides?
is
Like natural,
We can do now.
natural break point. Okay.
I saw it said 10:30, so I was trying to make it to 10:30. We can, whatever. you say.
Thomas,
Yes, ma'am.
before we break, I just want to make a point, and you can correct me if I'm wrong about this, but when you have more than one child client, as you were describing, how do you make that determination, similar to what Crystal was asking, as to when to make the decision to stay with, for example, representing all 4 children or not? Because here's where I think about this, and my pediatric nurse hat is going on right now. All of these children that you described were utilized, I'm thinking about the 4 you just mentioned, are at different stages of development.
Right.
And they all have different ideas about their parent and where they fit in with that particular parent or both parents. How do you deal with that? The 13-year-old, provided there's not a disability that we know of, is going to think a heck of a lot different than the 17-year-old. None of them have developed brains, so we all know that about teenagers or children, younger children. How do you come to a consensus on that? I don't know if that is that. Am I explaining that? I struggle with that.
I understand the question. It may sound, it depends, it's case specific, but it really is. So in that situation, the mom had a 1-bedroom loft apartment and she left, and the dad had the big house, and the mom had issues that she was trying to deal with. So it was easy.
Oh, okay.
Right. And, thinking of the young girl, she couldn't live with mom, but we did work out a plan so she would spend more time with mom. The 13-year-old boy didn't want to go with mom. None of them can live with mom. So I encouraged him to spend more time with her, even if it's not overnight, because he didn't want to, because he's 13 and, anything's awkward, they're not going to do. The 16-year-old boy didn't want to spend time with mom, and I can't really make him, but I encouraged him to maybe go with his brother. And the 17-year-old who didn't have considered judgment because of emotional disability, I encouraged her to go travel with her sister and perhaps spend the night, maybe one night a week or so, even if it's on the couch, because, they had a nice mother-daughter bond, but mom wasn't in a place physically, logistically, and frankly, emotionally, where she should have them very often. So, but if the facts were different, then that's where you have to make a tough call, like this particular attorney did in our case, where she decided that the 10-year-old should go live with his mom in Hagerstown because mom is able to calm him down better. And when Cynthia was talking about food fights and everything else, this kid is nuts. This kid assaulted multiple teachers. A principal concussed one of the teachers. Like, he's hitting him hard. And Howard County Public Schools, we're gonna, he needs a residential program. So, and he was doing this to his younger brother. So that BIA looked at it as what does the 8-year-old need versus what the 10-year-old needs, and she made the least worst recommendation to split them up, and they only see each other like every other weekend, because when they pass in the night, when one child comes to see the dad, the other one goes to mom, except for 2 weekends a month. I think that answers your question.
It does, Thomas. I think one key point here is that the BIA, whoever that is, and I'm using you in this instance, must be skilled, and you are. There are, because you can really do some damage to, not you, but an attorney who is not skilled could really do some damage among the children if they're not skilled in the process and knowing when to hold them and when to fold them, so to speak, I guess.
Right. This boy who's now in Hagerstown is still acting like ridiculous and causing the same problems, or trying to. And my client, who's the dad, says, we need to bring him back. We need to bring him back. And I have to keep reminding him, if you do that, you're physically threatened. You're putting your youngest child in danger, first of all. And that's why the BA is not going to do it. So,
right.
She's first and foremost trying to save this younger kid who's doing well enough while we try to get this younger one the services. It's awful, but I've certainly had cases where one child is completely enmeshed and is aligned with the parent and wants to be. You really have, which they probably don't have considered judgment, because the reasons for their decisions are not good. But that gets very tough, because then your client, who's a child, hates you. You're taking them away from their father or their mother, and
well, you said something earlier. You said no matter what the judge or the court see in terms of considered judgment, kids are kids. I mean, they think like kids, and that's a skill set. I think any attorney, BIA or not, has to recognize that kids don't always make the best decisions.
Right. Sometimes I'm involved with sitting them down and telling them, if you don't see your mom at all, and you don't talk to her at all, you don't FaceTime with her at all, you're really hurting her feelings. And, is that what you want to do? And when you're 30 or 25 or 40, well, we can do something different, but no contact at all. Is that really best?
Yeah.
So, that's.
Well, and I think we have to keep in mind that as the best interest attorney and not child advocate, that we decide we recommend what is in their best interest. And so it may not be what they want.
Yes, true.
Right. And so it's, you have to sort of work with your client. So I've had clients say, you're not doing what I want you to. It's a 14-year-old girl who has thoughts and opinions, but if I don't think it's best and I'm the BIA, then I'm not going to recommend the schedule that she may want. And so I have to sort of work with my client to get her to sort of agree to what I'm going to propose, or, she doesn't have to necessarily agree, but you want to have a good relationship. So it's sort of walking that balance outside of a courtroom.
Yes. Yeah, I see.
So this is going to be my response if you're a BIA in my case, is that the role of the judge is to receive all the information, to assess it, and make a decision. And so to the extent that the BIA has done just that, then the BIA really has made an independent assessment, come to some decision, but that's usurping the role of the court. And really, so that the court really should do that, just that. That's the court's job. And so to the extent that the BIA disagrees with me, then disagrees with my client, then my argument to the court is, Your Honor, the BIA is an advocate for what the BIA has determined. I'm an advocate for my client, the other side's an advocate. But the BIA is an advocate also, because BIA has looked at the evidence and assessed it and decided that this is what should happen. But the BIA's decision, a recommendation, is not entitled to any greater weight, that's the court's job. And so, the courts, I'm presenting my case, I'm presenting my argument, and Your Honor, I'm gonna ask you to determine independently on the facts and to make your decision based on the facts.
Well,
And to not give any greater weight to a BIA recommendation. That's gonna be my argument.
that's the state of the law, but why don't we go to the next slide and we can see how the BIA should get all the information and assess it. So kind of bundled this into the different, you kind of change roles as you go, because now we always invest, even as people who represent a party, we have to get our facts, right? That's what discovery is. But BIA investigates, and they have the ability to investigate some things that we cannot, and get information that we cannot. So they're going to meet with the child. It'll more than once for sure. And the longer the litigation goes on, the more you should check in. And depending on the age of the child, I'll text them from time to time if they're old enough. Hey, everything cool? Just, because they don't really want to talk to me anyway. Or it'll be quick, just swing by real quick. If the child's younger, you have to take a different approach because you're trying to also build rapport. And then one of the things the BIA should do is observe the child with each parent at least once, even to watch the nonverbal interactions, because Doris is right. We're going to give our opinion, and that's all it is. But with any opinion, whether it's an expert opinion or a lay opinion, what's the basis of your opinion? If there is none, then the court gives it the weight it deserves. But we're also gathering information because the next phase is to problem solve, try to put out all the little fires we can. And by the second time I meet with the child, I'll say something like, if there's like one thing that one or both of your parents could do or not do, just like one little thing, what would it be? Like, maybe they'll do it. And it might be a really big thing, but I'm just presenting it like it's nothing. And then I'll talk to them and say, hey, I don't know if you knew this, but when you always bring your stepdaughter to your visits with your daughter, she doesn't feel very special. Like, that's me advocating to help them get closer. Just an easy example. Or there might be the way the two people talk to one another, but same way when you're doing mediation, you look for low-hanging fruit, try to make some settlements, try to build some rapport try to build some trust between the two people. But the BIA is there for real-time intervention if necessary, if they can do it. And Doris is right, we don't make decisions. But if something's going on and it is emergent or an emergency, then we have the right to file for an emergency hearing. And Doris is right that we don't make decisions, but the court has trusted us enough and value us enough as a professional that they appointed us. And they also made people pay to do this job. Now, you're welcome to, file something to try to remove, but similar to when the social worker who works for the court is working and there's that personal rapport with the court, presumably the BIA has one as well. So, that may or may not be the case, but the more veteran the BIA is, the more likely that they've done this over and over and over again. And the court trusts the person to do a very good job and be very, very thorough. But that, if it goes to trial, we'll talk about that in a second. But along the way, I feel like, and I'd be interested in Karen's response, I feel like if there's a BIA, we should get this to settle, because we should always be trying to settle without a BIA, and all the mechanisms are in place to try to get you to settle. And then along comes additionally this other layer of services, the BIA, who should be all along saying, well, why don't we move the exchange from the school parking lot, where there seems to always be a problem, to you tell me, and then we solve that problem and put out that little fire. But and if not,
Well,
then
and I certainly agree with that, Thomas. And it is invaluable if I am the best interest attorney and I can tell my clients, this is what the schedule is going to be, and your mom and dad or moms or whatever came to this decision together, as opposed to a judge deciding. So if we're close on something, I'm always pushing. Like, it is so important if I'm going to be able to tell my client, your parents agreed to this.
this slide goes on to, what the last to final role of the BIA, and then the slides kind of back up. So I'll come back to this litigation portion. But as Doris said, if there's no settlement, then there'll be a trial, and then the BIA participates and they advocate for what they believe is best for their client or clients. And we'll talk about that a little bit more, but they do it as an equal participant. More towards Crystal's point is the next slide. What are the considerations for appointment? If you ask the court, well, how does the BIA get appointed? It's probably too many, but parties, I don't know about the parties, but if they're both represented, you could both call up each other and say, yeah, this seems like a good case for a BIA. Do you want to do that? If everyone says yes, okay, file a joint motion. But just a second, I'll make sure I'm staying somewhat through the outline.
Thomas, you want to take a break before we get to this part, or do you want to?
All right,
I'm gonna say yes.
there it is.
I need to use it.
5 minutes?
Yeah.
Nancy, we're gonna take a break.
Okay,
but,
5 minutes.
We'll be back. We'll be back in about 5 minutes. And I will turn it back over to Thomas.
Okay. I might have. Let me go through these next slides, which will perhaps answer Crystal's question about when should I ask for a BIA? Should I ask for a BIA? So we're on that slide. This is what the court will consider. So we passed around a sample motion asking to appoint an attorney for the child, which happens to be Karen. And from the court's perspective, and yes, I did ask people, judges and magistrates and family law coordinators about this, but we'll get to the factors. But they're going to take a look at these things you see on this slide. But it's also up to us to put that in our motion clearly. What courts like you to do, some courts more so than others, meaning I can speak for Howard County, their unwritten policy is you can file a motion if you want, but they'd rather if I call you up and say, do you agree to a BIA in this case? Independently, whether yes or no, if the court appoints one, can we agree on who that would be? You could say, I don't want a BIA. I said, duly noted, I got you. Okay, I hear you. But hypothetically, if there is a BIA, do you want to see if we can agree on who that would be? Okay, you may say, no, I'm not going to agree. Okay. Third independent question, hypothetically, if there's a BIA, can we agree on the fee split? If my client makes a lot more money, obviously I'm hoping you're going to say 50-50. But you may say pro rata, or you may say, well, if it's going to be one, your client has to pay for all of it. Okay. I'm not going to get in an argument about it because I'm just going to note that in the motion. The opposing counsel does not agree to BIA. We cannot agree on the identity of the BIA, and we cannot agree on the fee splitting because they're going to want to know that. But if any one of those three things are agreed upon, that helps the court. In any event, then you have to file a motion. And when you file the motion, you want to explain why, and I think this goes in directly or perhaps directly to your question, why it is a BIA is needed. Now, there are factors in the rule 9-205.1, which is the next slide. But before I get there, you may want to point out other information that doesn't match up with one of the factors, like the nature of potential evidence. That will inevitably go to, are there confidential communications? Because if so, you want BIA that has the NAGL privilege, the child privilege part of it, to waive or not, or assert. So there's that. Then there's DSS or CPS, because you can try to talk to them. Good luck with that. Teachers, principals, you can talk to them, but you probably have to depose them. So there's that. But let's flip to the next slide, which are the actual factors. So this is in a lot of our cases, but I think I'm hoping that this is answering your question, Chris. That really is at the heart of like why we're even doing this training. Like, do I need one? When do I need one? So hopefully you don't have all of these in your case, and some of them can be addressed by not using a BIA. Like if there's actual threat and family violence, that's what petitions for domestic violence are for, et cetera. But I wanted to make sure you had the factors. And then if we can go to the next slide. So these are more, written in English. Why, when, how can this help? So they just can't co-parent and it's affecting the child. And the child is acting out in the many ways that you described this one kid doing. Gatekeeping, alienation, marginalization, et cetera. In any situation where you need a deep dive on the facts, where you can't get that information, you can't do a home visit, you shouldn't be talking to the kids. When I was a brand new attorney, I did that once and I got in big trouble. Never again. So if anyone has questions about that.
The one thing that I would point out is that the court has the authority to decline to appoint a best interest attorney. So I had a case one time where I agreed to a best interest attorney, opposing counsel did. We agreed on who it would be, or if not, the court could appoint someone. And it was in Baltimore County, but the judge denied it and said no need for a best interest attorney. So that doesn't happen often, but the court ultimately decides, and it can happen.
Yeah, it probably was a little bit shocking.
Yeah.
There is a couple different ways to get a best interest attorney. Is obviously by agreement or joint motion, or by you file your own motion, which we just sent out an example. The court can also sua sponte appoint one. And that's when you have a magistrate who has a lot of experience or a judge who used to be a magistrate, a lot of experience, and they just look at this, usually at an evidentiary hearing like Pendente Lite, and say, wow, this child, these children need a BIA, screaming for a BIA. Once or twice, I've had that happen in a protective order, in the sense that, before Sarah kills me, it was at the circuit court, and this judge would be hearing this custody case anyway. Really, the judge was saying, this child needs a BIA, not in this case, because I don't think they can do that. They can, but in the custody case. And, we're gonna work our magic behind the scenes and do that. So, and when it comes to who will be the BIA, it all depends on the court. Usually there's a group of, well, first of all, you have to be on their list, which means you have to take the training, get a certificate, submit it. Now, on their list means a lot different things in different courts. When I was working in Baltimore City, you were never going to get one unless you did a couple pro bono. And Judge Carrion assigned me to one, and it took 100 hours. But you don't say no, because they call you. Like Judge Carrion herself called me, which is probably not right. But, never complain, never will. They're like, the answer is yes. It's not a question. And so some courts are like that, and that's fine. But they're going to give you, if it's pro bono, they're going to give you ones that they feel are easier. So that breaks from what I was saying about when you're appointed as a BIA, it's always an awful and a very hard case. If they're asking you to do one pro bono, they're going to give you one that they think is easy. Like, Sarah, how did they start you off with that case with 9 kids? Was limited?
I had a limited scope BIA appearance where I had to meet with the children, review records, and then make a recommendation prior to the, prior to the, was after the summer conference? We had a status conference in front of the magistrate who heard the first, I guess it was appeal hearing. So it was limited scope, and I had to talk to 9 children who didn't speak Korean or English fluently.
Right. So that was, required much more work.
It was easy in the end, though. It was so obvious what should happen.
Thomas. Sorry to cut you off. The other thing that people should realize is that sometimes the court will also sua sponte order a custody evaluation. Howard County's pretty well known for it these days, in my experience.
Yes. Yeah. So the court's looking at many different things, but it could be that when you think about, do I need one? Do I think I need one? Maybe the children are older, but so they might have some information that is needed, and you don't want them to testify because they probably won't be allowed to testify. But so I really want to make sure I answer your question, because I think that's at the heart of what's going on. So that's why there's multiple slides. But a lot of these things happen in every custody case. But if the child is stuck in the middle and they're suffering because of it, then that's when the child would be best served with an attorney, because that attorney should do everything she can to stop and let them fight amongst themselves, but stop passing notes, stop passing messages, stop saying awful things about the other parent to the child. Tell your buddies, the softball field, at the bar, at the gym, whatever. You're at your book club, tell your friends, that's fine. You hate him, she hates you, you hate her. Okay. The kid doesn't need to know about that. And certainly if there's parenting behaviors that are harming the child, parents, when they're hurt, when I was when my kids were younger, I would say, hurt people hurt people. Mm-hmm. So they say some disgusting things to their kids about them sometimes, about the kids, but certainly about the mom or the dad. So the next slide is, how can a BIA help you? Can't really, we can see it on yours, but they can access privileged information. We talked about that before. Ask questions if you have them. The third one, recommendations to strengthen the relationships. For example, I had a case where the father was a retired Army colonel from Alabama, and the mother was a nurse anesthetist or a doctor, or she's an anesthesiologist. So this guy is old school. And when the boy acted up, he got whooped. Okay, because that's how the colonel grew up in Alabama. That's fine. I don't judge that. And it was not abuse under the law. But the boy is growing up now in Maryland suburbs, and that's not what happens to all of his peers. And it was horrifying for him and scary. But the dad is thinking, well, yeah, I want you to be scared because I don't want you to do what you're doing. You know, some of us may have had a little bit of that growing up. Okay. So I had to talk to him, and I just played the dad card because no judgment. But if you want this to be better for you, and if you want to take it off the table in litigation, because they're screaming bloody murder about it, then, you know, maybe there's some other things we can do. There was also a custody evaluator involved, and he was a bit, is a bit academic, and certainly he didn't grow up that way. You know, timeout's a little harsh for him. So I said, this is not playing well for you, but I'm not here for you. I'm here for the boy, and the boy will feel closer to you if he's not scared of you, and if you all can work. And he actually took that advice, even though I know it's hard for him because he probably felt like I was criticizing the way he was brought up. But that's an example. You know, the mother was doing other things. She was overscheduling the hell out of this kid. Good Lord. So I had to talk to her about that. But I don't have to, but my job is to move the kid out of the middle and protect the best interest. The husband would come into the house after he left to pick up the boy. He would come all the way into the house, put bags of groceries in the kitchen, and you look around a little bit. Like, why don't we not do that? Because I appreciate that you're bringing groceries. Anyway, he didn't understand. He wasn't seeing it from the kid's perspective. Then the mom asked the kid. So that's how we help to settle and resolve cases as we go along so that it doesn't go all the way to trial. Karen, Jessica, anything on that?
No, I think what people need to realize is that if their clients aren't taking the strong recommendation of the BIA, that it could appear negatively for that party if the case does not resolve itself and has to go to trial.
Yeah. In some cases where the parties' roles were different before separation, I'm thinking way back to a case when I was a BA and Jessica represented the father. The father did a lot, but the mother was very much a helicopter parent, and she just didn't see the father's value at all. So sometimes you have to try to help the other side, not the other side for me, but both parents see the value of the other parent through the eyes of the kids. Otherwise, it sounds like you're making a value judgment. But, and you start off with the fact that they both love you. They love you both, excuse me, and you're the two most important people in the world. But, and then you might say, from what I'm seeing, he or she does a bit more than that. I can see why you're upset, but I see this, I see that, I see that, which means the court might see this or that or that. But
Thomas, you're really aging us on that one. Thank you.
I think one other thing that I wanted to add is that when the BIA is appointed, the order will generally say, the fee split. So you make sure that your client takes care of that promptly. And it often will say, that one party will forward pleadings, and make sure that you just don't look at the order to see who was appointed, that you follow any directions in the order. It's important to get the information that your client may have to the best interest attorney as soon as possible and cooperate as much as possible. You will probably quickly receive a letter from the best interest attorney saying, here's the rules, here's what I would like. If the best interest attorney wants to meet with your client, make sure that your client does that promptly. The last thing you want is to have the best interest attorney not getting cooperation from your client, not paying, whatever it is, right? So cooperate as much as possible, give information, keep the best interest attorney in the loop as the case goes along.
The other thing that letter from the BIA might also say, just to piggyback on what Karen said, is that they will ask permission of counsel if one of the parents has counsel to speak to that party without counsel being present. So you also need to be mindful of that too.
I'm sorry, can you repeat that?
Yeah, sometimes the letter, it should, a best practice in my opinion, would request, it would be a request by the BIA to a parent's attorney to give permission for the BIA to speak to a represented party, right? Because otherwise
I would never
technically,
do that.
yeah.
Never do that.
I'm not saying, yeah, correct. And so the BIA often in that initial letter will ask permission to be able to do that. And it's obviously between the parent and his or her counsel to make a decision on how to respond to that.
No, I would say you can meet with us and I will defer to you and your conversation, but I'm not going to agree not to be present.
We've had that in a minority of cases. We've had that, and that's totally right. And the BIA has to respect it. I certainly have. I have had situations where, well, every time that happens, it gets a little bit, I guess awkward is the right word, when you have to do home visits, because inevitably the client, who you, in this case, you would represent, wants to ask me questions and wants to say some things, and I have to say, I would love, I appreciate whatever you want to say, but you really, please don't, because Doris made it clear that she wants to be there. So you give her a call now, or we'll just table this, write down what you want to say, run it by Doris, you know, and I have to say that very politely, because one, that's the right thing to do, but especially they'll like start talking to you while the kids are there. I don't want to, you know.
And I realize that because that's what, you know, clients are concerned that you're going to have, they want to put the best foot forward. Couple of things I think the BIA is expense, okay? My clients don't have money, so I'm doing good to get paid myself. So coming up money to pay a BIA is always a problem. But you know, you have to do it. What Thomas describes, the way he conducts is kind of like a model BIA. That doesn't always happen.
Truth.
I have been, I'm thinking back to one case in particular where the BIA was totally on, I was representing the mother on the father's side. And in fact, I think she was MVLS, she might have been MVLS side. She was totally on the father's side. I think because my client couldn't pay, and there was an order for them to contribute to the BIA, but my client didn't have that much money. And so I don't know if she had made her entire contribution or whatever, but there was no question in my mind that, I mean, she actually was more of an advocate for the father than the father's own attorney. And I felt she could subjected my client to this withering cross-examination. Like I felt like this should not be, even if she wants to make these points, it should not be this one-sided. And so you know, I think you may run in, like I said, what Thomas is describing is the model. But you don't necessarily always run into the model.
You're absolutely right. And I think that was a good point you made earlier when you basically said, sometimes you have to take it to trial because you disagree with the BIA. And just like the custody evaluator, the basis of their opinion might not be good. And we're human beings also, and I frequently have to check our own biases to the side. Hopefully I don't get in trouble for this one, but well.
Maybe not.
No,
Don't do that one.
is not the crowd for it. But you sometimes you get this initial communication from one side, and you're like, what okay. All right. It's an email. Who knows what? Let me just put that off to the side and do my business. So yeah, or sometimes people say things, and sometimes it's the attorney. I have a sample letter here. I didn't give it to you all. I more than once had to threaten an attorney with contempt because if you look at this sample order appointing counsel for minor child, goes the way down right below the date which I'm supposed to assert or waive the privilege. It says the party shall fully cooperate with the attorney appointed herein in the performance of duties. I don't know what that exactly means, but refusing to send over the documents or refusing to make the child available or refusing to do anything, well, that's not in compliance. One attorney who practiced for a long time sent me requests for admissions. I had to write a letter and say, I'm not a party. I can hear someone laughing. I don't have any firsthand information in the first place, even to admit or deny this, but and you can't ask my kid this. So it's just silly. But the order will say whether or not the BIA is also a child privilege attorney or not. If it's not there, you're not. That's a tough one. I think it can be inferred, but we don't really do inferences in law, right? So, but then it goes on to say who pays what. And in this case, you have a split that's not 50-50. That looks like 70-30. And then it explains that I have, just because this is for me, the BIA has on the first page, reasonable access to all privileged information, confidential or otherwise, et cetera, to include medical, dental, psychiatric, psychological, DSS, et cetera. The reason I point that out is because I have more than once had third parties, one time a therapist, one time a teacher, say they're not going to meet with me, even though the first sentence of my intro letter is, I do not represent mom and I do not represent dad. I represent the children. You and I are in the same team. I respect you, et cetera. And then you have to send I always send the order appointing and highlight that part. With teachers or principals, I'll also say, please contact your school board legal representation so they can tell you that this is true. And sometimes there's a 2 week or 2 lag and they say, we contacted and I understand. Or sometimes the principal wants to be there with the teacher. Okay, that's fine. I don't care.
Some school systems just ask that you send it to them directly too.
The
Howard and Frederick do.
The school board.
Yeah.
Yeah, the lawyers for the school board. One therapist refused to talk to me at all, and which is really weird in the first place. And then she put her boss on to talk to me, who I knew from their website was her husband, which was also weird. And he talked to me like a mad husband. And I'm like, well, you're a therapist, like you understand, like emotions can get into, but then I had to write a letter that said, look, I need the information. You could talk to me confidentially off the record because I don't have to reveal this, or the only other choice is to depose you, which means I have to decide, I guess, to waive the privilege before I know what you're going to say. So those are your choices. But of course, you need to decide if you really need to go there with people. But because it is, again, to Doris's point, very important that whether it's a custody evaluator, private or court or the BIA does their job right and thoroughly, and my bias is to the kids. So I might think that the dad is the coolest dude in the whole world, and I can't believe the way that woman talks to him. So that has nothing to do with the best interest of the children unless it's affecting them somehow. Or it might be go the other way. Like, what a jerk, I can't believe it. So that on that point, the next slide is something that we've already discussed, but if you have questions about that, about any of these things, of course I'm joking, they're not really superpowers, but they're abilities that when I'm representing mom or dad, I can't, or I'll have a lot of problems doing it. But doing these things as a best interest attorney will give you a fuller picture. That said, at the same time, I know that Karen does, as do I, as does Sarah. We try to be surgical. Like, you can't just do a whole bunch of work and run the bill way up in the air. Does anyone have questions about how a BIA gets paid?
Yeah, how did they get paid? Because you can barely get it like Doris, you can barely get them to pay you. So like, how do you get them?
Sure. And this is important for you to know too, because you have to manage your client who is getting pretty upset because they don't have control over the BIA bill. So the BIA bill comes probably once a month, and whether they're paying half or what's this, 70%, like, oh my God, they're just off the hook, just doing whatever they want. Well, then maybe you should never ask for them again, and you can try to lightly talk to them about it. But that doesn't usually work because it's like if it's exactly like if the opposing counsel called you up and said your bill is too high. In Howard County, you're paid $200 an hour for your first 10 hours, and then you go to your customary rate, which you can go up to that, or you could do kind of your own sliding scale, which is what I do. But if Doris is billing $400 an hour and Curtis is billing $350, it's going to be in that range, because especially when you guys are probably going to make me do most of the work to like find out all the custody stuff. But it doesn't have to be. Sometimes we stay at 200 because people are really struggling. And then I will call up the attorneys and I'll say, how can I help you decrease costs? And we'll try to do something with, maybe we can come to some stipulations, et cetera. So first the clients have to pay upfront pursuant to the order. That's like initial retainer. To get that money, all depends what the order says. In many jurisdictions, the initial retainer, you simply file a line. So you're not asking for the money, you're just saying, I'm taking it, here's my billing statement, I'm taking it up to the full amount of the initial, because you've already authorized it, but you can see it all works out, unless someone complains. I usually send it in advance, wait to see if anyone complains, but I haven't done that in a while. Then after that,
just
yes.
a question about retainers for the BIA, and I think every BIA has a different practice, but what happens in your experience, like if a party doesn't pay the BIA retainer? I think technically, depending on the jurisdiction, some of the orders say that the BIA does not have to start work until both parties pay the retainer. Now I think every BIA handles that slightly differently, right? Whether
Yes.
they follow that or if they file, for example, a contempt or just some sort of line to notify the judge that one party is paid and the other party hasn't, for example.
Right. It's a great question. If your client's the one who's not paying, you have to remind them that's a court order. Our time to object to that. That's why we gave you a copy of the motion. That was your time to object to the BIA or my client cannot pay, here's why, and you lost. Because the order says you have to pay X amount of dollars. So, and I will remind my clients, the problem is you're paying me to talk about not paying the BIA when there's an order for the BIA. As much as I'd like to get paid, there's no order. So to answer Jessica's question, The
I
issue of
also think
malpractice,
there is some negative implication if one of the parties doesn't pay too, to the court, right? Like, how can the court perceive that about a parent's genuineness or ability to actually put the children's best interest first, for example?
sure. And it's kind of like it's kind of like child support in the sense that if your client pays nothing, then good luck trying to prove to the court you're not in contempt because because you're arguing, I do not have the ability to pay $1. That's contempt. Pay $100 and you owe $1,000. So are they going to pay anything? So to answer your earlier question, what do I do? Malpractice comes into play, and the best interest of these kids. And again, first world problems or whatever problems, I only get assigned in these awful cases. So for me to say, well, I'm not going to do work because someone hasn't paid $1,800, but I already have $4,200 looking at this order from the other side, that's going to harm the kids. That's going to look bad to the court. That's going to affect my reputation as far as being appointed in these. Morally, ethically, you might think it's the wrong thing to do. It's a tough choice, but they are violating the order, and I will communicate with their attorney that it's an order. Please discuss this with this person, because if not, I will file contempt, and it'll just be really clean.
What about where the order says final allocation of fees are determined by the court? Can you get them back then?
So Sarah's pointing out that in this order and in many, the final allocation can be determined later. But that doesn't mean that the parties don't have to pay the initial amount. It just means it can be readjusted later, which it almost never is.
Well, I just meant in your example where you start with your 4,200 because the other person didn't pay 1,800.
Right.
The court can still order that later.
They can order a reimbursement later, but it's going to look, in my opinion, feel pretty confident on this one. It's going to look really bad if your client is paying you, which they're not ordered to do, but not paying their children's attorney. So it is in the nature of child support. And I say that because it is not discharged in bankruptcy. So like the law literally says it's in the nature of child support. Once the initial retainer is gone, the BIA will file a request for replenishment and explain to the court briefly why it is they need more money, what they've done before, how much they need. And then the court will issue an order ordering both parents to pay within however many days, X amount of dollars. And then you're right back to the same problem, except now you don't even have it yet. So you're working like you sometimes do with your own clients, hoping they're going to pay you later. But
or you become a collections attorney at the end of the case.
Right. You become a collections attorney at the end of the case, just like you do when it's your own client, except they can't discharge you in bankruptcy. They try. But and it's a pain in the butt. And at least with them, when they put a bad review, you can say, well, I wasn't your attorney. You can respond that way. But
and the court would be quick to enter a judgment. If the court orders fees at the end of a case, you pay X and you pay Y, and they don't pay, then you can get a judgment against them.
Well, the practical advice I give my clients is, this is a person who's going to make a recommendation to the court about what should happen. And so in the very practical world, let's not alienate this person from the outset. So so you need to gather those funds, because presumably the court has determined that you are capable of paying that, because if I would raise inability to pay from the outset at the motion. So if I've already raised that and the court has determined that that you're capable of paying this amount of money, then you need to do that. You need to come up with that because that's not only a court order, but also it's a practical issue in terms of what's best for your case. You don't want to alienate the person that's gonna be making a recommendation to the court. We may or may not agree with that recommendation once it comes, but let's not start off.
And there's nothing wrong calling up the BIA and saying, hey, would you take 500 now? And then, my client will make payments, because the BIA doesn't want to have a adversarial relationship about the money. They just want to help the kids and get going. But I always tell my clients, or anyone, when it comes to payment of a debt, like, don't call me up asking for a payment plan unless you're paying something and then you have a plan to pay more, because otherwise you're just saying, I'm not paying you anything now. But those are great points, Doris. Let's see. I
do want to make one comment about the not having an ex parte communication with the judge. Because I was in another training where an attorney who had been had represented children commented, well, sometimes I will go back in chambers with the child, and the child goes to speak to the judge. And so my response is like, no, you're not. If either we're gonna all go back there or nobody's gonna go back there. Because that does have the potential for ex parte. And so, I would not defer to, and this is not just BIA, but like Senate cases and so forth, that if there's going to be a communication with attorney, with the judge, you were all going to be present, or nobody's going to be present. And I generally, no objection to the child talking to the judge, but if any counsel's going back there, we need to all go back there.
So one of the things, and this goes to Doris's point earlier, and if the court's going to appoint you as a BIA, they generally have a lot of faith in you, but you also need to live up to that. So, it's like the line made famous by Spider-Man, but that came well before that, with great power comes great responsibility, and vice versa. It's you. If a BIA files an emergency hearing, the court looks at it differently because you're a neutral. And as we all know, the best interest of the child is the paramount concern of the court. So it'll probably be granted. And if it's probably granted, you're probably on your way to the relief requested therein being granted. Maybe not. It's not a one-to-one correlation. But you also have to, as the BIA, shouldn't abuse that. But it's another way that we can encourage people to settle little things along the way and to eliminate if something's becoming emergency. And this all goes to, we are trying to get folks to settle. So if we could go to the next page, this is just kind of what happens along the way. Very similar to what the regular attorney does, except we have to keep checking in with the children, and then we have to keep checking in with these third parties that are behind the scenes, because we should not get to a trial. We just shouldn't. And if the attorney is doing if the BIA is doing a bad job, okay, then maybe you go to trial. Brief story. I had a very significant case. It was actually the one with the colonel and the doctor, and I finally got them to agree on a shared physical custody schedule that favored the mom, because that was in the boy's best interest. And it was in the boy's best interest to spend time with his father, who had put himself geographically in a better place so he could do that, which was also at my suggestion when I said, I really don't want my client in traffic for 40 minutes a morning. That's my opinion. And if you want me to go along with it, then, you know, you have the means, put yourself in a different location. And, you know, his attorney also agreed, but that wasn't the real issue. So we settled physical custody. They would not settle legal custody. This doctor really wanted her son, as she put it, who was going from 5th grade to 6th grade to go to McDonough, because that's where her friends send their kids. First world problems. But they live in a very elite school district, public school district in Howard County. And the elementary school's in the same parking lot as the middle school. Now, sometimes that happens. So 90% of the kids are going from this elementary to that middle school. And sometimes the middle school teachers will come over, especially, you know, towards the end of 5th grade, to meet the kids. They already know the teachers. Like, this is like, you may as well build a tunnel. It's the same school. The boy was excited about it. No reason to move him. Amazing middle school, as middle schools go. We didn't want to do it. And then there were other issues, like how many different types of taekwondo and chess and, you know, ancient Latin is he going to take? But there were silly things. And so legal custody was going to be an issue. And they were scheduled for 5 days of trial. And the settlement conference, we couldn't get to move, but the BIA and settlement conferences, the judge sits at the head of the table and the BIA sits at the foot of the table. And the judge usually says, let's start with the BIA because they're neutral, assuming they did a good job. And we give our perspective very, you know, subtly, and then maybe not so subtly as the conference goes on. And they just wouldn't agree. And towards the end, I just got up and I said, let me tell you something. I shouldn't have said this. I said, you're about to spend $30,000 on me. You're going to split it in half. It's going to be $30,000. Ask your attorneys. On the issues of McDonough versus an amazing school, or 3 taekwondo and chess tutoring. That's not reasonable. It might not even be sane. You're going to spend $30,000 on me. And no attorney ever says this to you, so listen up. I'm not worth it. And the judge looked at me, and then the mom's like, no, I think you are. You know, my son and I think you're great. I said, that's not reasonable. And then I left because it was time to leave. And we had 5 days of trial because they won't, courts don't usually bifurcate the property and the custody because it's somewhat intertwined. And then we had 3 more days of trial. I was like
6 days?
8. I was doing like whatever. I mean, they were talking about their vacation homes. I'm like, I can't believe this. Like, are you every day? You sure you don't want to settle this? Nope. So, okay, we had the child custody evaluator on, I pointed up because he was on Zoom. It's ridiculous. But, and shocker, what I recommended is what happened. And after all that money, which they paid. So, you know, but I don't really know. I actually fine taking it on that one because I told them don't pay me because I'm not worth it, and they did. But yeah, so you're right, Doris. If the BIA is not doing a good job or has too much bias, then you have to take it to trial. But it generally becomes 2-on-1, and that's when I think it gets, you know, that's when one person is just being unreasonable. And a colleague of mine says, she works in the court, if a divorce or custody case goes to trial, that means at least one person is crazy. At least. So I tell my clients, it's not going to be me and it's not going to be you. And then we'll see what's up with everyone else. But the other 2 slides are redundant. I now see that. Sorry about that. But that's a drawing from one of my cases where the boy was, you know, really upset, and some of the things that the dad was, and the mom's, you're worthless, gay, stupid, fat, ugly, egotistical. Mom may be talking to dad. I don't think so. That's not my recollection. And, you know, dad's like, you're ashamed that you're my son. I mean, what the heck is wrong with these people? Sometimes you you need a third person to take custody, but this is your role. You're supposed to comply with the court order. We talked about that. You can absolutely participate in interviews because that's your right. Like Dora said, you don't have to let that happen without you. You should advocate and you should keep providing updates because your job is to continue to demonstrate your client's position. And sometimes that changes. Facts change, just like our own custody cases, right? Your person out of the gate may be fantastic, and then she takes a left turn or something is discovered and you're like, it's just the way it is. Like, I know what I told you in the beginning, and these three things make it totally different. And so what I'm gonna.
And I think that, I'm
Please.
sorry to interrupt.
No, please.
That also goes for, I may have asserted the privilege, and at some point during the pendency of the case, I would have the right to change my mind, and I may want to waive the privilege. Rarely, but it could happen.
Right. Yeah. And again, our reason for doing this is to help you understand that that is normal. That's within the rights of the BIA. And we're trying to help the kid. We're trying to help both of them be better parents for the kid's benefit. We're trying to get you to settle. And if we can't, even if we jump up, stand up at the table and say, don't pay me $30,000, if you're going to make us go to court, then now we're a litigator. And while we can also settle just like you can in the courthouse steps or in the hallway during lunch, we also don't have to. And Karen, have you ever had a situation where both parents agreed on something, but you as the BIA thought it was not good enough that you couldn't sign off on it?
I don't think so.
Yeah. I've come close.
I've come close as well, but usually if they, it may not be the way I would parent but I rarely would oppose something where I would not have the parents agree. I can't think of a circumstance where I've done that.
Yeah.
I think you came close on our last case.
Well, yes, very
that.
close.
And I wasn't thinking of that when I asked you. I just a question.
I wasn't thinking of that one either, but that's a good one, Sarah.
Yeah. But it can become 2 versus 1. It kind of should be, because you're trying, as a BIA, you're trying to get the parents to agree with how you see it, assuming you see it reasonably, because you might not. So if it's 2 versus 1, that's an awful situation to put your client in. And I tell my client, you're crazy. First of all, you're paying that BIA half to fight you, and you're going to lose. And it could make you look unreasonable. It could expose you to attorney's fees for the other side. Maybe. I know with MVLS cases, that's not likely. But when it comes to the BIA's role in the litigation, part of the reason we're even having this session is because many people on the listserv were asking questions about it and didn't quite seem to understand that you're the third attorney. We get our own trial table. There's no client sitting next to us. And it's, let's just use heterosexual couples. Sorry, people, but dad's attorney, plaintiff, makes her opening statement. Mom's attorney makes her opening statement. You make your opening statement. And in that statement, you must say, does your client have considered judgment or not, and why? You must say their preference is this, but again, they don't have considered judgment. So the only reason I'm telling you that, Your Honor, is because I have to. It doesn't mean anything. But you lay out your case. Same thing with the closing. And it takes longer because every time there's a witness, there's a direct, there's defendant's cross-exam, there's BIA cross-exam, so there's 3 rotations instead of 2. And if a judge is going to let there be redirect, then there's going to be recross and then a BIA recross. It takes a while, but you can issue trial subpoenas, of course. You absolutely can object, and I just had a question about that came to me over the listserv. You can call your own witnesses. You might not need to, because you would think, one, it's rare BIA goes to trial. And then when that happens, you often have attorneys that are very thorough and calling up everyone and their cousin. So it's very rare that you have your own witness, but it might be an expert. It might be someone that only you can call, like DSS or it's like therapist or whatever. And of course, you have to follow all the rules and the scheduling order deadlines, just like anyone else. There are the same way, I know I'm being recorded. So the same way we may add a little bit of information when have a speaking objection or when we're just making argument to the court, and we say some things that might be inadmissible. It's not evidence, right? It's just argument. BAs do the same thing if you're good, but we might all agree that when we do it as client litigators, attorneys for clients, that may be in the judge's mind, especially if the judge thinks you're honest and good attorney. Same thing with the BIA, except that they see you as a neutral, as someone the court trusted to appoint, and there it is in the subconscious. Is that good or bad? I don't know. We all do it.
Well, I will tell you, I think it's really important what you pointed out about stating your client's position and whether they have considered judgment, because the BIA's recommendation might not be in line with the child's desires. And, you're going to get into, how old is the child and should that child's opinion be respected irrespective of what the BIA may recommend. But the other issue, which is something you had up earlier, is hearsay. I'm going to fiercely object to the inclusion of any hearsay from the child. The child's position is one thing, but everything that's coming in that record needs to come in, and it needs to be admissible under the rules. It's not the child's attorney saying stuff that's not proven by independent means.
Sure, and a good BIA would have that come in other ways or have those facts demonstrate something that's consistent with his or her opening and closing statement on that point. So, of course, but also with experts, that's one way of, hearsay coming in, because that's what's the basis of their opinion. But I understand what you mean. And I just wanted to point that out because that's part of the art of litigating, and BIAs have a little different tools. So, yeah, and I don't think it can be understated that even though even Doris is absolutely right, BIA is just an attorney. BIA doesn't make decisions. However, if I would research the BIA a little bit, just like you probably do the judge. The judge is like straight out of some white shoe, blue blood law firm, dropped in, doesn't know squat about family law. You need to know that. If the BIA is brand new, doesn't know what she's talking about, you need to know that. But the BIA has been doing this for 20 years, especially in a smaller county where everyone knows it, and they're active in the bar or whatever. They got BIA attorney of the year. I don't know. You need to know that too before you start saying this person has no idea what they're doing, and I've never seen. Just. Of course, maybe we don't advocate like that anyway, but you would have already had so many months experience with this BIA, working with them, getting buy-in, asking for suggestions. I always ask my BIA, what can my client do better in your mind? I might completely disagree with the suggestion, but why wouldn't you ask that? Don't you want your client to be a better parent for this child? Why wouldn't you ask that? And then if she can do it, then I'd be like, do it. Why wouldn't you also do that? So you shouldn't still be all the way in trial by then, but that's why I have the cooperation up there and this little diagram of the BIA being like, hey, why can't we just? So that's a big part of the job. Help people settle, help people make concessions and be better to show that you're protecting and advocating for the kid. And the reason I'm telling you all this, again, is not to teach you how to be a BIA, but to understand, why is this person doing this stuff? Like, what's their deal? And parents get mad. Like, why are you telling me how to parent? So I address that first. Like, I'm telling you, this is how I see it based on what I'm hearing from other people. You can take it or leave it, but I just think it'll make your life easier in this case, if you want a selfish reason. And I think it'll improve the quality of your relationship with your child if you want a reason that benefits your child. Do what you want to do. So, and that one lady wanted to go to trial over McDonough. Okay.
Oh, well, let me say this. If there's a BIA, I'm gonna do my best to try to get them on my side. But if I can't, let's go to trial.
Well, if I'm not on your side, it's my job to show you, like, here's 5 reasons why, and you'll probably be like, yeah, that's true.
Yeah, but I've won, just me and my client, against the BIA and the other counsel. And one case I'm thinking in particular, and it actually was, the BIA did put on the record what the child wanted, but she was recommending something different than what the child wanted. And the child, I thought she was what, 10 or 11? So, we all do what we have to do. We all do what we have to do. And if we have to go, like I say, my, best case scenarios, try to, if there's a BIA, there's going to be one, I want that BIA on my side. But if I can't get them on my side, then, I'm going to make all of those arguments to the court about why the court should not give such great weight to their recommendation.
And custody is always modifiable. So.
That's the material changes.
Yes. Nebulous definition, but right. It's just I don't know if there is any Q&A or horror stories, or Jessica or Karen want to share something that really will help people to work with BIAs or child privilege attorneys or custody evaluators, or child advocate attorneys, although that just kind of is what it is. I do have one last handout. It's called Divorce Rules, which I got a long time ago, which is I give my parents in these cases, because I tell them these are things you should or should not do, because kind of common sense. If we have it electronically, you can recycle it. I will not be upset with that. Oh, you put your own clients. Thank you.
Thomas, can I have one of those? Actually, those might be helpful for us. I gave her one. You might want to just take the 20 off the top of it. Right.
Have it electronically. One time, a younger or less experienced attorney said to me, well, I'm not going to pass these on. It says 1999 at the bottom. These are 25 years old. And it's not like, thou shall not, I don't know, not, whatever.
1999 seems like the other day.
Oh, yeah.
The rules still hold true today.
Absolutely. It's like things I learned in kindergarten.
Yeah.
Same.
The basic stuff, you know, don't pass notes. Don't give the little boy a check, child support check, the memo line says something, words I can't repeat.
Mhm.
Don't deliver your child support in pennies. Not nice.
Yeah. Does anyone have any questions at this point?
About the presentation or?
Presentation or other questions? That I know Kendrick had a couple of questions. That he wanted to, we have a little time, so.
I got the majority of them answered. I really just have two questions, 1.5 questions. Does anyone have experience with Judge Ruth Jakubowski? Is that how you say her name?
Yeah, plenty.
Oh, I have just a settlement conference with her tomorrow. Just want to know any tips or anything I should be looking out for.
She is the most experienced judge I know in Baltimore County. She used to be the administrative judge, so she knows her shit. When you go in there, I mean, she probably,
No, Jakubowski.
Very child focused too.
yeah, very child focused, very friendly. You're gonna love her.
Oh, okay.
That's the only advice I have.
Okay, good. And then I have the MVLS case. It's a 3-year-old. The parents are not married, not together, haven't been together except for, I guess, the night of the child's conception. It's a Spanish-speaking father. I'm representing the mother. And so he's really apprehensive to do anything outside of the court, which I'm completely fine with. But that joint statement, is that something that should be filed in this particular case? But there's been no communication between them two, and I've only been able to get him on the phone one time, so I don't think.
The sort of a joint statement before the trial.
Yeah, before the settlement, the joint statement of decision-making and
Parenting plan.
time.
I read that, yeah.
Some courts will require that. I went to default about 3 or 4 weeks ago, and the court made us file that joint parenting plan, even though it was just her. She'd had the kids, but they still made us file that.
No,
I
was in Howard County.
MVLS case with a Spanish-speaking client, and the father was also Spanish-speaking, and there was a settlement conference before Judge Jakubowski. I don't think we had come in with a parenting plan. It didn't matter to her. You know, she was very practical. We reached a agreement on custody, but not child support.
okay. And I think the way that speaking to the mother and then even the father to some extent, I really think this would be resolved. I think they just want it solidified, a judge order to say this is what I need to do.
I mean, the translator was very helpful.
Yes, and the translator will be there.
Yeah. She did expect me to do the order, so if you reach a resolution, I expect to write that up.
No problem.
I think, yeah, she had asked to email it to the other side and like include a statement, which was, I hadn't heard that before, but like at the bottom of the order that it's been shared, even though he didn't sign.
No, perfect. Thank you.
I've had a lot of luck using Google Translate when I'm working with my clients, but I'll always put it in English because usually they can speak enough English. And reading it, you can kind of put it together, but then I'll just put it different color font in Spanish, kind of like the court pleadings do when they're in Spanish. If you ever saw not pleadings, the pro se forms.
Okay, yes.
Yeah, I think it's in Spanish, in red font in Spanish, but that's not exactly.
Will translate on your phone when you.
No, well, sometimes, but I like to be able to see it because I know enough Spanish that that doesn't look right.
If this is, I think this is for your MVLS case, you can also get, if you do end up having to use a translator, you can get that covered by the litigation fund. That's like a pro bono resource.
I think the court, because he requested one, so it's the other party that needs the translator.
Okay.
He's requested it.
Okay.
Part of your problem that he's per se and doesn't want to work with you.
Yeah,
Right. So
yeah.
you can also file it individually. You can still file it individually if it comes to that point. So if you
No.
don't reach a settlement tomorrow and you need to file it before you go to trial, just include in a line that the per se individual didn't want to work with you.
Oh, okay.
That works too. The important part is that the court has it.
All right, perfect. Thank you.
But I would try and reach out to him in email so that you have something in writing to attach saying you attempted to work with him on it and he refused.
Yeah, okay.
Jessica, does that sound right to you? I know it's Baltimore County, but you must have run into that problem when you're working with the magistrate of Baltimore City where.
Yeah, I see people just put like, in the title where it says joint statement of blah, 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 like a footnote that says like, I reached out to the other party on this date, never got a response, so we're sending it.
Yeah.
And we accepted that.
Perfect. All right. Thank you.
And just so everyone knows that there is a program that we work with called by the name of IUTA. And IUTA will do some translating of documents. You won't have time to do that by tomorrow. We are having a meeting with them sometime next week, I believe, where we're going to talk about some issues that we've been having. Right now, they're primarily focused on taking those cases, translating cases involving those clients of ours that reside in Prince George's or Montgomery County, although they will consider other counties depending on the situation. And so our meeting is going to try to extend that among more counties than just Prince George's and Montgomery, but that is an option, and you can certainly reach out to them. You know, you won't have it, you would never have it by tomorrow, but just in the future, let me know and I can send you the links that you may need to do that.
Okay, perfect. Thank you.
Nancy, should we move into the?
I think
awards
so. I
portion
think
or certificate
so.
portion of the presentation?
Absolutely. If no one has any other questions about their cases or have any concerns, what I'd like to do is have us move toward our graduation.
Yeah.
Can I just
We should
say
have
congratulations to all the
Yes,
graduates?
congratulations to everyone and
Because I'm gonna have to
thank
get
you
out of
all
here.
for participating in this. We really appreciate it. Nancy, anything else you would like to say, or should I start giving out the?
Well, I just want to say that it was a privilege working with all of you. It was really an opportunity to bring some new talent into our family law program, and I thank you all for agreeing to be a part of this wonderful cohort. So with that, I will let, I wish I could be there in person to shake your hands. Congratulations to all of you. And with that, I'll let Margaret.
I think what we'll do
hand out.
is, yeah, if both the mentee and the mentor are here, we'll have you both come up. If just the mentee is here, we'll invite you up.
And
So
just as a little FYI, we're going to be taking photos. Chandler, who's in the back of the room, is going to be taking photos for our social media. And so smile pretty and
Kriya, who's on the screen, I want to recognize you as one of our mentees as well. We will send you your certificate since you couldn't be here today.
Thank
All
you.
right. So first, I have hers first. So we will go ahead and send that. Congratulations to you. Hudson Miller. I didn't necessarily think that this is the music, but this is very exciting.
Oh, Margaret, can you hear water bottle?
Water
Yeah, I am.
All
This
right.
looks good.
All right. I thought you were going up there with me.
Jessica.
Oh, that's right. I'm sorry.
Jessica's
I
here.
got mixed up.
Haven't met you yet.
I mean, informally.
All right, Kendrick McLeod.
You're doing it.
Yeah, everybody needs music, I think.
I don't know.
I have, yeah, like, actually gotten to know Hudson.
Jessica Keister.
Yeah.
Crystal Collins. All right, congratulations to everyone. I think that wraps us up for today, but you know, even though the cohort is officially, I guess, wrapping up, please reach out to Nancy, reach out to myself, you know, participate in the listserv. Like, we definitely want to stay connected with everybody and continue to be a resource for all of you.
And in time, hopefully, you will all be able
On the
to
Judicare
join the
panel.
Judicare
That's our
panel.
goal. We'll be paying you as well. All right. All right. Thank you, everybody. Don't
Thanks,
forget to
all.
say what you
Appreciate it.
fruit as you go. Yeah, thank you, Chandler.
Curtis. Time we don't have.
Yeah, this initial.
Full circle. In a way.
Yeah.
I want to ask a question.
Basically,
Should
like, every day
I
after
sign
that's
off
more
or you think
serious.
another case?
Ones that we just ran into.
Well,
this-
Same time.
This reminded me of.
What was that, Margaret?
Week
Signing
ago in
off.
federal court where you're holding.
Signing off to
Idaho.
Okay.
A very short period of development for me.
Yes, thank you so much.
Yeah, a lot's been going on.
Not up to the time.